today, can I just give you the wins from the week without having to do the receipts that I normally do? Because I'm finding I'm just overwhelmed with life, my clients, my business, my family, and my obligation and promise to give you the weekly wins. So if I beg your indulgence. Normally, I like to put the screenshot from the cases on the side so you can follow along. That is going to slow me down. So for now, let me just give you about 13 wins, which is great. We did have 2 really devastating losses from the Supreme Court nonetheless. So I'm going to touch on those. You probably know what I'm talking about. But let's just start with the good news, shall we? The obvious news is that Kilmer Abrego Garcia was returned. We'd been asking for him to return. Judge Paula Zinas in the District Court of Maryland was about to find the Trump administration in contempt for not doing that, and she allowed the plaintiffs, Kilmer's attorneys, to file the formal request for a contempt. And surprise, surprise, they say he was extradited because he's being prosecuted for a 2022 traffic stop, which led to an investigation about human trafficking, and he's part of that ring. Blah 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 blah. No one believes me, believes him, no one believes her. See my other video that I just did on that. 2 different decisions determined that the Trump administration cannot get rid of the AmeriCorps and the JobCorps without following the proper procedures under the Administrative Procedure Act to explain why they can do that. And also those 2 entities, I believe, were created by Congress. And so it's ultra virus for the executive to try to dismantle something that was created by Congress. It's a creature of Congress. Only Congress can dismantle it. And by cutting it and cutting funding is the same effect as dismantling it. And you can't do that without proper procedures. So they had a temporary preliminary halt of that pending the outcome of the lawsuit. So that's 3 cases, wins. Another case is Judge Boasberg in the District Court of D.C. decided to create a class out of everyone that is at SCOTUS. You know, in March 15th, the Trump administration took about 234 Venezuelan migrants and a bunch of other people. We know they sent women, they sent non-Venezuelans there, and the prison in El Salvador said no and returned the women and the people from the other countries. Anyway, the Judge Boasberg said that because the Supreme Court said it's okay to create classes of people in each jurisdiction, that he's going to go ahead and create a class for the people in SCOTUS. And he said, I'm not going to tell you how to do it. I'm going to I'll give you a week for you to decide how are you going to give those people access to a lawyer, an attorney, information, and ability to present that they are not members of that violence gang and they do not deserve to be there. So you got a week. Clock is ticking. Yay. That's another win. Another win is that the Harvard University, Judge Allison Burroughs had already told the Trump administration, pursuant to an executive order, to try to strip away the J and L visas, student visas from the Harvard, and declassify or essentially remove Harvard's certification as an entity that can host visas from students. They tried another way, and Allison Burroughs said, my order that says you can't do it this way means you can't do it another way. So you create another executive order to do exactly the same thing. And by the way, they did this before. You follow my account. My name is JJ Legal here. I'm watching all the different cases, over 200 lawsuits filed against the Trump administration in the dockets. I'm in the dockets. I'm helping you understand in layman's term what's going on. One of the things I like to do is have a weekly wrap up of the wins. When I started doing this, like when the beginning of this administration in January, I used to do them every single day. But as you can imagine, it got overwhelming. So now I do this once a week. Another win is the Department of Education was being dismantled by the Trump administration. Donald Trump issued an executive order calling for this dismantling. Linda McMahon made a statement saying that the last act is going to reduce the force and fire like 1,600 people. And Judge Myung-Joon said that because the Department of Education was created by Congress, only Congress can dismantle it. And by doing a reduction in force, that's essentially the same thing. But let's say you exceed your authority and you're allowed to, and you want to dismantle, there's a process. They didn't follow the process. So when they don't follow the process for doing a reduction in force properly, which it's really detailed, there's a lot of steps to it. Since you're not doing the proper process and proper steps, the way you've done it is wrong. You have to roll that back. A 3-panel judge on the First Circuit Court of Appeals agreed with Judge Myung-Joon and said that that's true. Donald Trump has appealed that to the Supreme Court. So we'll see what happens, but that's a win for now. Yes. Another win is there is another application of the Alien Enemies Act to someone named Darwin Meldrin. what's his name, and he essentially went to his immigration hearing. He's part of this new campaign of the Trump administration where they go to hearings where people who have availed themselves to the United States government seeking asylum or refugee status, or perhaps they're allowed to come here pursuant to a temporary protection status, when they go to the immigration hearings for the usual check-ins, ICE officials waiting for them essentially, and sometimes in some cases the judges dismiss the deportation removal cases. So once they do that, the people are still in this country. Now Donald Trump can arrest them and subject them to this new administration's process, because under Biden administration, they're entitled to a certain process that can take a long time. And so they want to remove them from Biden's process, put them in Trump's process, which is expedited removal, just trying to quickly get rid of these folks. Now, when this person was removed, he knows he's Venezuelan, he has tattoos, he knows the next stop is SCOTUS or some other prison, torture prison. So he filed a suit, and the judge said while Donald Trump may have a case in terms of for invoking Alien Enemies Act, he said that he can't remove this person. He has to follow proper procedures. He has to give this guy an opportunity to defend against the accusation. You saw my last video, I say they often just accuse people of stuff based on random nonsense without really little basis. So someone has an autism awareness tattoo, and this guy had a tattoo related to basketball, and they're saying, no, that's gang related. So they're just making up shit. And that's the basis they're sending people away, because they have a tattoo related to something that they don't understand, the little racist brains don't understand, and they categorize it as gang. You're Venezuelan, you have a tattoo, you're gang. So they're really operating on just the most ridiculous of standards. The judge certified a class. It was Northern District or Middle District, Central California, and decided to certify a class. So this person came, I believe ACLU probably was representing them, not only on behalf of himself, but others. I said that because of what the Supreme Court, which says that everyone's entitled habeas corpus, what the ACLU has been doing is going from jurisdiction to jurisdiction certifying class. So there's a class in New York, there's a class in Colorado, I believe. Yeah. And there's a couple of classes in Texas, and now there's this class in California. So wherever there's a Venezuelan that the Donald Trump administration come and try to, their Venezuelan descent, they're just saying now that we need you first to attack us. Once you attack them, they go to a judge. A judge says, pursuant to what the Supreme Court says, you can't remove this person without process. And you have to have a full hearing, and you have to bring the evidence. And at the end of the evidence, you haven't presented enough evidence this person's part of a gang, you can't remove them pursuant to that. They have to go ahead and continue with their asylum case or their refugee status case. A couple of more. The Judge Mayun June, the Northern District of California, had already previously found that the Trump administration improper. There's the cases that I've already mentioned, the Guatemalan man, ODC, who was returned. There is Jordan Salmaron, who I did a post about before, mistakenly deported. He should be returning. And then there's the South Sudanese that I mentioned in the previous post that a judge says they're entitled to due process hearing, and they're having one in Djibouti, where the Trump administration has a base. Finally, they were ordered to give gender-affirming care to prisoners, pursuant to a district court judge. I think that's it. Now let's talk about the bombshell losses we experienced at the Supreme Court and what it means.
What's most frustrating about the Supreme Court decisions recently, the ones that seem to be procedural wins, like I've mentioned, and the last one actually has some substantive aspect to it. And what I say is that for the most part, the Supreme Court has only said substantively given instructions to the Trump administration, and they're kind of like losses 3 times before recently, saying that the Trump administration must pay off the invoices owed to the USAID, telling them that they have to afford due process habeas corpus hearings to the migrants that they wish to ship off, and to facilitate return for Kilmer, Abrego, Garcia. Everything else has been like a procedural wins, like saying, letting Donald Trump not have district courts nationwide preliminary injunctions, blocks on his activities go into effect while the cases are being officially litigated. The court system is slow. There's depositions, there is discovery, there is there are hearings, there are motions, there's delay, there's time. So before you get to a resolution, a final order, it can take years. Last time Trump was in office, some of these litigations he just abandoned. That's why he lost something like I think it was like 90% of the time, his first term, because Slope was just really super slow, and his whole agenda, everything he wanted to do, couldn't get done. And that's what I understand. They say insanity is doing the same thing over and over again and expecting different results. He did this last time and didn't really get what he wanted, because a lot of his agenda items that he wanted to skip the steps and just go straight to do it. And then the courts would say, you can't do that. There's certain processes. And he's doing it again. He's again skipping the steps. And this time, not only is he skipping the steps, he's skipping the steps, and he's being brazen with it. And he's doing executive order, and he's talking about it, and he's bombastically like presenting it and just like making it a big deal, and just, hoping that the media, people just being fear, and he's chaos through people not understanding. And that's how he is able to present himself as winning. But then he gets back down and he tells you people, oh, it's the judges. No, you consistently do things that's unlawful. Anyway, I digress. So procedurally, they've allowed Donald Trump to pause the effect of nationwide injunctions while the cases percolate. And that's what these last three cases, Biden had given a deferred parole, which is similar like a temporary protective status to people from 4 countries, Nicaragua, Cuba, Haiti, and Venezuela, given the turmoil in their countries, instability, lack of opportunity, lots of stuff. So you're getting like 600,000 people initially in 2021, and then again in 2023, extended through 2025 to 2026 for some of these people. And Kristi Noem came in and said she's going to revoke them. Several judges say in order to revoke them, you have to have a reason and basis. It can't be racism. So in both cases, they just said you're calling these people violent thugs, but just based on nothing other than just your racist hatred for them, and no more than that. You need actual facts, actual evidence, and they don't have evidence. They just have racism. And so the judge is like, bring the evidence. We're going to pause this until you can go through the final authentic process for revoking these TPS statuses. You can't revoke them. And so what happened was the last time regarding the TPS just for Venezuelans, and this new one that they did recently related to the deferred parole, which is kind of like a TPS for these 4 nations, the Supreme Court allowed a stay or a pausing of the effect of the nationwide ban blocking Kristi Noem from removing these people from the country. So because they've lifted the block, the Trump administration could arguably start processing and removing these people from the country. Now, Justice Ketanji Brown Jackson, in her dissent, to which I believe Justice Sotomayor joined in, Justice Kagan did not, said that we do a balancing when we decide to grant stay or deny stay. And if we were doing the balancing act, we would determine that the people who paid an application fee, who paid for their own flight, were able to get someone to sponsor them, an American citizen or green card holders to sponsor them, who are not, to the extent that they're working, they've established roots, they have done nothing, and removing them, the government doesn't need to remove them. There's no emergency basis for them to remove these people who are doing nothing. Meanwhile, on the flip side, to disrupt people with stable lives, they've sold everything or whatever they have at home, they purchased their ticket, they have their kids in school, they have jobs, some of them started businesses, they're stable here for the next 2 years, that's disruptive to them. So the stay should not be granted, because we would balance the interests of the people who are already here. Their interests outweigh the interests of the government, who haven't really proven they're harmed below. And we should trust the district courts below. When they looked at the dockets, they looked at the case presented before them and the pleadings, we should trust their decisions, that they made the decision to stay based on what they see. We, the Supreme Court, are not going to see that. So that's frustrating. And that's what she said, Justice Ketanji Brown said in her opinion, and I'm not being precise with it, but essentially that's what she said. And she also previously said we need to stop accepting these rocket docket emergency cases, appeals from the executive, because it's not really an emergency. They just don't want to wait through the process. They don't want to be blocked. They just want to come to you and inquire and whine to you. And you're eroding and deriding the esteem and the history of the Supreme Court by doing this. And they are. And that's what she's warned them, and they're continuing to do it anyway. Not quite sure why. They're doing it again. So while it's not an outright win, because it's really just a pausing, morally it is, because it's time and time again. They did 2 of those back to back, and then ones that's to Doge is so conflicting. It's frustrating, because on one end there was a watchdog organization that wanted to get access to Doge's records, and so in this end, this is the most recent one, Supreme Court, and this is where Supreme Court actually issued something substantive. They said the courts below, by pausing it and opening it up so Doge can actually provide access and prove why they are indeed not subject to Freedom of Information Act request. That's asking the executive to prove that they're worthy. I don't know what they were trying to say. It's really confusing. Even when I read it over and over again, they're saying that the Supreme Court, well, the conservative justices, all 6 of them, told the court below, they're remanding it, sending it back, says it's too broad to just say open it up to Doge, and give the executive branch more leverage. They're giving the benefit of doubt to a lawless regime that they see as lawless. They see that Trump is not abiding by the district court's decisions below, and they see that he's being unruly and disruptive and want to undermine the credibility and even usurp the authority of Congress and themselves. And they are strict constructionists, and they are all about the balance of power. And they, each of them, for the most part, in the past pleadings, have said they want to uphold that balance of power. But they all seem to want to give the executive, want to expand executive authority to a certain extent, and that's why they're doing this, I think. And so because they want to expand the executive while Trump is in office, they're willing to say give deference to the executive when you go back down. This is what they're telling the courts below. When you look at this case again, don't allow the people asking for Doge access so much access, and narrow it down. And when you narrow it down with giving deference to executive, this lawless executive. That's what they've said. And which is bizarre, is because Trump's not going to be in power forever. And what they're saying essentially is when there's a Democrat, that's going to apply when there's a Democrat in office. And I'm hoping when a Democrat gets into office, most likely next year, we're lucky, give it to Donald Trump, so to 4 years, these decisions are going to hold true. The fact that you want to expand the executive, are you going to want the executive's power to be expanded when it's a Democrat president? Is that what you want to want? I'm not sure they want that. They want to give Donald Trump minor wins just for him, not knowing that this ebbs and flow, it's cyclical, and it's, that it's not always going to be a Republican in office or conservative in office. Anyway, so that's what they said. They said, so that was kind of a substantive kind of win by telling the courts below that they need to get more deference to the executive. So I think that is a substantive. That's like their first substantive win, in my opinion. In that case, they also said allow Doge to have access, said let them do the work. So in one realm, you're saying that they're not necessarily the type of agency that should be subject to wide-ranging FOIA, Freedom of Information requests. That's what you're saying in one opinion. And then the other opinion, you're saying that they should be allowed to continue to do their work while this challenge to whether or not they can do their work and they have access continues. That makes sense. If you allow them to continue, they're going to do the damage. You should pause them, because the nexus of the entire case is whether or not they're authorized to have access to information. So why would you let them continue to have access to this information while in another decision saying we're not quite sure their level of executive, their level of agency that should be subject to FOIA? If they're doing this stuff, granted, yes, they're the level that should be FOIA, your decisions conflict, and you're just like bending yourself backward and twisting to not, it's just so much conflation and confliction of your opinions, because you seem like you don't trust the Trump administration. You see them doing unlawful stuff and you're ordering him to do what's right, but then at another end you still want to give him power. You're just like, you're all just at battle, at odds and wits, and it's kind of like you need to have more principle and get it together and follow the liberal justices' leads, and because they kind of know, regain your power and stop yielding it and over to this guy. Anyway, JJ Legal. That was long. I was frustrated. Anyway, I hope that's helpful. I'll try to do better and have these more available on a weekly basis. I'm working on it. Each one teach one.